Morning. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is February 27, 2019. The time is 9:30. With us today are Commissioner Emily Lindley, and for our General Counsel's Office, Ms. Mary Smith. My name is John Neerman, and I'll ask Ms. Smith to begin the proceedings.
Item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application by the City of Dripping Springs for TPDES permit number WQ00144-88003. Several people have signed in and indicated that they do not wish to speak. Their presence will be noted for the record. The order of presentation should begin with the applicant, followed by the protestant, the ED, and then OPIC in that order. By letter dated February 8th, 2019, the chief clerk notified the parties that they will each have 5 minutes of oral argument. The applicant may reserve some time for rebuttal as it bears the burden of proof on the application. Mr. Tuckfield is here for the applicant.
Good morning, Mr. Tuckfield. Mr. Tuckfield, I'm sorry to interrupt. We want to make two things. Make sure your mic is on. And,
I'm so sorry.
And if you could repeat for the record your name and affiliation.
Sure.
Thank you.
My name is David Tuckfield. I represent the City of Dripping Springs. Now it's loud. I wanted to thank you for the chance to speak to you. The City of Dripping Springs has been working on this permit since 2013. The city is a growing area. It has been, it's thriving. There's lots of construction and lots of building. People want to live there, and there's an extreme need for this permit. This permit will assist the city not only in its contractual commitments with those that are building in the City of Dripping Springs, but with its plan for extensive beneficial reuse through Section 210. The city is committed to it. They're contractually obligated to it, to a massive amount of beneficial reuse, and they're going to do that. We appreciate the administrative law judge and OPIC and ED staff and attorneys and their thoughtful analysis. The city started this. There were well over 1,000 comments with this permit. We settled with LCRA. We settled with all the other named parties, except for one, Save Our Springs. After a 3-day hearing with 13 expert witnesses, the ED and OPIC agreed that the applicant met the burden of proof on all the referred issues. This permit is, I just can't stress how important this permit is for the City of Dripping Springs, and we appreciate your consideration. I'd like to reserve the rest of my time for rebuttal.
Thank you. And Mr. Bunch, if you're here for Save Our Springs. And I think we have your exhibits here.
Okay.
I'll ask you the same thing to state your name and affiliation for the record.
Yes, thank you. Chairman Neerman, Commissioner Lindley, Ms. Smith, I'm Bill Bunch. I'm Executive Director and Lead Counsel for Protesting Party Save Our Springs Alliance. With me today are my co-counsel, Kelly Davis and Chris Mullins. We're protesting this matter in part because we have a member, Mr. David Penn, his family, who owned the first major property downstream of the discharge, a 500-acre plus ranch that straddles both sides of Onion Creek. We have many other members who depend on clean recharge waters from Onion Creek and drinking water wells in Dripping Springs, and of course many others who rely on Onion Creek to provide clean recharge water to Barton Springs and the Edwards Aquifer further downstream. We're asking you to reverse the proposal for decision on 3 main points: that there's inadequate notice to justify jurisdiction, that there's no need whatsoever for this permit, and that the permit violates very clearly the Tier 1 and Tier 2 anti-degradation standards in your rule. Now, the 3 of you are very well schooled in this on these standards, so I'll move quickly through this and have a limited time. And probably won't say much about the first 2 matters and focus on the anti-degradation standard, because that's really the core here and for a bunch of other permits that are following us. I also won't have time to talk about the pink bathtub, but I wish I would. The first slide that you have shows Onion Creek as one of the crystal clear, pristine hill country streams that are naturally extremely low in nutrients, nitrogen and phosphorus, with an assemblage of species that have evolved in this incredibly nutrient-deprived condition. The plant, which is the only place that was given a location in the notice, is at the far right, lower right, both east of 12 and south of 150. The discharge point was over a mile and a half to the northwest on the opposite side of 12, north of 150. No meaningful reference for that discharge point, with lots of intervening property owners who were not given adequate notice. So that's the orientation there. Let's see. The decision you make today, though, on the anti-degradation standard will either open the floodgates for a series of permit applications that would ruin most of our pristine, very low nutrient streams across the limestone hill country and in specific areas in Texas that have similar geology, like the Cross Timbers District and parts of West Texas. The science that this agency has funded and EPA has funded over the last 18 years establishes beyond any dispute whatsoever, and this is in the record, research led by Professor Ryan King at the Center for Reservoir and Aquatic System Science at Baylor University, with co-researchers from Texas A&M and the USDA, that you simply cannot add this enormous nutrient load, particularly phosphorus, to a small pristine hill country stream like Onion Creek and not impair existing uses and not also a lower water quality by more than a de minimis amount. Those are the two standards in your anti-degradation rule. Tier 1, prohibiting impairment of existing uses, and Tier 2, prohibiting any lowering of water quality of any kind beyond more than a de minimis amount. We respectfully submit that reasonable minds simply cannot differ once you look at this evidence that's undisputed in the record. For decades, nobody even asked for discharge permits in the hill country unless they had a really big river like the Guadalupe to discharge into, because they understood that such a discharge would violate Clean Water Act, swimmable, fishable, and anti-degradation standards. So across this region, you see the Texas land application permits, which prohibit discharge and provide the treated wastewater irrigating off-site on land and being assimilated by the soils and plants. In the last couple of years now, you have a flurry of applications by people who expect this agency to ignore the overwhelming science that this agency has funded and helped develop and ignore the law and grant these discharge permits that would turn these crystal clear hill country streams into green slime messes that are inhospitable for swimming and would completely change the existing ecosystems from assemblages of species, from algae to invertebrates to fish, that have evolved in this very low nutrient status, and replace them with a whole different assemblage of biology that has evolved
Mr. Bunch,
in the higher nutrient
I'll ask you
conditions.
just to take a minute to wrap up.
Okay. The slides that I did provide and didn't even get to show the applicant's own data with orders of magnitude increase, 2 orders of magnitude increase in phosphorus and nitrogen, order of magnitude increase in algae growth. That in no way can establish a no more than de minimis lowering of water quality. As a matter of law, this permit needs to be denied. Thank you.
Thank you. Commissioner Lindley, do you have any questions for Mr. Bunch?
No questions, thank you.
Thank you, sir. Executive Director.
Good morning, Commissioners, General Counsel, Public Interest Counsel. I am Kathy Humphreys with the Environmental Law Division. With me today is Lily Murphy with the Water Quality Division. The Executive Director respectfully recommends the Commission adopt the ALJ's proposal for decision with the Executive Director's proposed changes to findings of facts 8, 27, 37, 57, 85, 103, and 104 as recommended in the Judge's January 8th letter. Thank you, and we're available for questions.
Thank you. Commissioner Lindley, any questions?
No, sir.
OPIC.
Good morning, Chairman, Commissioner, General Counsel. I'm Garrett Arthur for the Office of Public Interest Counsel. As stated in our, as stated in our closing argument, OPIC found that applicant met its burden of proof on each of the referred issues. Our position is based on the weight of evidence in the record, including the additional evidence presented by the ED to support the draft permit. The ED recommends that findings of fact 107 and 108 be amended, and OPIC supports the ED's proposed amendments. We also support the ED's recommended changes to findings of fact 8, 27, 38, 57, 85, 103, and 104. Finally, the ALJ recommends that finding of fact 122 be amended and finding of fact 129 be reclassified as a conclusion of law. OPIC supports both recommendations. In conclusion, we respectfully recommend the application be granted and the permit issued. Thank you.
Thank you. Commissioner Lindley, any questions?
No, sir, not this time.
Mr. Tuckfield, you have a few minutes for rebuttal.
Thank you. I just wanted to raise a couple points. Mr. Bunch brought up notice, need, and anti-degradation. With regard to notice, most notices are sent out saying that the discharge goes to an unnamed tributary. In this case, it was named, and it was named with Walnut Springs, and that's a phrase that SOS's own expert used in their pre-filed testimony. It was clearly marked. It's on a USGS map. There just cannot be any dispute that the notice was perfectly adequate. It was more detailed than most notices that go out. Secondly, with regard to need, he really didn't discuss it, but I think the PFD adequately explains that there's certainly just a great deal of need. I've been involved in numerous wastewater contract negotiations where we've had to say, look, you're going to have to design a septic field. If we don't get this permit, you'll have to build that septic field, and if we get the permit, then we can do that. And so it's causing lots of consternation down there, because people are having to design things that hopefully they won't ever use. And let's face it, we'd much rather have it sent to a wastewater treatment facility than have these septic fields out there. And there's testimony in the record about that. It's not just me, but there's testimony in the record on that. And with regard to anti-degradation, Mr. Bunch cited the King study. Page 17 of the PFD addresses the King study. And in fact, what the ALJ says, and what we agree with, is that the King study actually says that streams exceeding 0.2 to 0.5 may represent another threshold of biological response that requires an investigation. And that's exactly what happened here. The city and the ED undertook the investigations necessary to determine what needed to be done, and it was perfectly appropriate. And so 0.2 for phosphorus is higher than the limit anyway of this permit, which is 0.15. So and I guess the last thing, Mr. Bunch didn't get a chance to discuss his exhibits, but they address oligotrophic and mesotrophic boundaries. These are not adopted by TCEQ, and all these boundaries it was a statistical study that somebody did. They took all these streams and they divided it into thirds. And if they'd taken different streams, it would have been different thirds. And so it's a statistical analysis is all it is, and it proves nothing. And so these oligotrophic and mesotrophic boundaries that he has on his exhibits just it's interesting, but it doesn't prove anything.
Thank you.
Thank you.
Commissioner Lindley, any questions or thoughts at this point?
No.
My view, I think the ALJ is correct that the applicant has met its burden on this application. I also think the ALJ's recommendation for apportioning the cost of the transcript is appropriate, and I'd like to hear your thoughts.
I would agree. I think the applicant meant the burden of proof in this case, and so I would be ready to make a motion that we approve the proposed order.
Go ahead.
Okay. I move that we adopt the ALJ's proposed order as revised by the ALJ's letter dated January 8th, 2019, with the following changes. A, add new ordering provision, number 2, to state, Save Our Springs Alliance shall reimburse the city of Dripping Springs $1,000 for reporting and transcription costs for the hearing of the merits. And B, add new ordering provision, number 3, to state, the executive director's response to comments is hereby adopted pursuant to 30 TAC 50.117 and renumber the remaining ordering provisions. Approve issuance of the ED's draft permit and adopt the ED's response to comments.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries.
Item number 2 is the consideration of the ALJ's proposal for decision and proposed order concerning the enforcement action against RATE Inc. The order of presentation should begin with the ED, followed by the respondent, and then OPIC. By letter dated February 8th, 2019, the chief clerk notified each of the parties that they would have 5 minutes of oral argument in accordance with the commission's standard practice. The ED may save time for rebuttal as the ED bears the burden of proof. The executive director's staff is here to present the item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Ryan Rutledge. I'm an attorney with the Litigation Division representing the Executive Director in this matter. With me today is Had Darling of the Enforcement Division. The ED concurs with the Administrative Law Judge's proposal for decision and recommends adoption of the order and the inclusion of the ED's exceptions. We're here to answer any questions you may have and would like to reserve the remainder of our time for rebuttal if necessary.
Thank you. Any questions?
None at this time.
And Mr. Days Hotel is not here. No one signed in for the respondent.
Nobody signed in for the respondent.
Okay, hearing none. OPIC.
OPIC agrees with the Administrative Law Judge and the Executive Director. The parties stipulated on the record that respondent committed the violations, and the ED also presented evidence establishing occurrence of the violations. The record further shows the penalty was calculated in accordance with the Commission's penalty policy, and the proposed corrective actions are necessary and appropriate. For these reasons, OPIC recommends the Commission approve the proposal for decision and sustain the minor exceptions filed by the Executive Director.
Thank you. Anything in there you'd like to rebut? Assume not.
That'd be correct, Commissioner.
Thank you. Commissioner Lindley, any thoughts or questions or comments at this point?
My only thought or comment would be that if you'd be comfortable, I would move that we authorize a payment plan for the.
Yeah, I might even go one step
Okay.
further than that. I think our investigators did an excellent job here. Staff did a good job. The ALJ did exactly what they were supposed to do. This is by the book, according to our penalty policy. But I feel like we reached the wrong result despite all of that good work. And I've, particularly what gives me concern are the discharge monitoring reports. We cited a dozen violations for reports of really no discharge. And that seems to have really pumped up a penalty beyond the bounds of what I think is just on these particular facts. And as a starting point, I might suggest that we cut the penalty by very roughly 2/3 and assess a penalty of $6,750. And in addition to cutting the penalty, cut the amount of time that they have to pay back down to 18 months. So $6,750 for the total penalty paid over 18 months would be my suggestion.
Can I take a 1-minute recess? I have a
You bet.
question real quick.
Yeah.
Thanks. I'm ready if you are. Sorry about that.
I am, yeah.
Okay, sorry.
So
I
what do you
had a-
think?
Well, I think I'm okay with that, and I just wanted to kind of confirm that we're not kind of setting any kind of new precedents here, then that your reduction or your suggested reduction is fact-specific for this case. So I just,
Yeah, I was
was
concerned
seeking
about the
clarity.
same thing. and
Yeah.
It's very rare that we adjust penalties when they're calculated appropriately. But I thought that this is a particularly unusual case, and the facts are particularly compelling here. And my view is that this should not be read as having any precedential value whatsoever as to any other case. I think that's
yeah.
the law of the matter. It's also
Exactly.
my opinion of the matter.
Okay, great. Then I would support a motion, which, if you want to make it, that's fine.
Yeah. So, Commissioner Lindley, I move that, that we adopt the ALJ's proposed order with the 3 modifications recommended by the executive director's exceptions and agreed to by the ALJ's reply, but that under the commission's authority, under other factors as justice requires, reduce the administrative penalty amount from $19,125 to $6,750 in conclusion of law number 13 and in ordering provision number 1, and that we authorize an 18-month payment plan for paying the reduced administrative penalty in ordering provision number 1.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Thank you.
Item number 3 is a hearing request on the application by the town of Lakeside for new TCEQ permit number WQ001556601 to authorize the disposal of treated domestic wastewater. The parties have been notified that the commissioners will not take oral argument but may ask questions. Nobody has signed in to speak on this item.
Thank you. Commissioner Lindley, this one looks pretty straightforward to me. Mr. Hawkins is located very close to the proposed site, and he has properly raised relevant and material issues relating to groundwater and nuisance. And so my view is that we ought to refer this for a contested case hearing on his request on those 2 issues.
I would agree. You know, I would just really encourage for those out there listening to, for all the parties to participate in ADR, and just leave it at that. I'm not going to make it an emotion. I would just encourage the parties to do that.
Yeah, I appreciate that. For those who aren't familiar, our office does have an ADR function, and we encourage all parties to use that.
I'm ready to make a motion.
I'll hear a motion. Thank you.
I move that we grant the hearing request of Philip Hawkins and refer the application to SOA for a contested case hearing on the following issues. A, whether the proposed permit is adequately protective of groundwater quality, and B, whether the proposed permit adequately addresses nuisance orders in accordance with 30 TAC Chapter 309, and set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
And I think that duration is appropriate. The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries.
Item number 4 is a hearing request on the application by Old Castle Materials Texas Incorporated, now known as Texas Material Group Incorporated, for renewal of air quality permit number 84703 to authorize the continued operation of a material handling and transfer facility and concrete batch plant. The parties have been notified that the commissioners will not take oral argument but may ask questions, and no one has signed in on this item.
Commissioner Lindley, on this one, I think we're compelled to deny all of the hearing requests. This is a no increase renewal. The applicant has a satisfactory compliance history rating, and so there's just no basis for us to grant a hearing.
I would agree.
I'll entertain a motion.
Okay. Yeah, and I will just say this one was kind of tough for me, but I agree because there is no increase in the emissions, and there's not an emission of a new air contaminant that hasn't been previously emitted. So they failed to satisfy the requirements of Senate Bill 709, and so I would agree there's no right to a hearing. So with that, I move that we find there's no right to a hearing on the application pursuant to Texas Health and Safety Code 382.056, deny all hearing requests, issue the renewal of air quality permit number 84703 to Old Castle Materials Texas Incorporated, now known as Texas Materials Group Incorporated, as recommended by the Executive Director, and adopt the Executive Director's response to public comment.
The motion has been made. I second it. All those in favor say aye.
Aye.
Aye. The motion carries.
Item number 5 is a hearing request on the application by Texas Concrete Enterprise Ready Mix Incorporated for new air quality permit number 150603. The parties have been notified that the commissioners will not take oral argument but may ask questions, and nobody has signed in on this item.
Commissioner Lindley, on this one, I think we're again compelled to deny all the hearing requests, and I'm going to lay out an analysis in 3 parts. We've had several requesters on this item, but under Chapter 382 of the Texas Health and Safety Code, those that reside more than 440 yards from the proposed facility don't have a right to a hearing, so that group is out. There's another group that failed to timely submit public comments, and so they have no right to a hearing under Texas Water Code, Section 5.115. And that covers the universe of individual requesters. We also had a couple of associations request a hearing, and neither of those, as part of their request, identified a representative that has standing in his or her own right, and that's a deficiency that can't be cured post hoc. And so, again, I think it's pretty straightforward that the law tells us who is and who is not an affected person, and we don't have an affected person with a right to a hearing in this matter.
I would agree, and actually I got ahead of myself. This one was actually the tough one for me.
Okay.
As opposed to item number 4. But I agree completely with everything you've said. The law is what it is, and so, I would also be supportive of denying all the hearing requests. And I can make a motion if you're ready.
Motion.
Okay, I will move that we deny all hearing requests, issue air quality standard permit registration number 150603 to Texas Concrete Enterprise Ready Mix, and, oops, I just got my pages turned around, and adopt the Executive Director's response to comments.
The motion has been made. I second it. All those in favor say aye.
Aye.
Aye. The motion carries.
Item number 6 is a hearing request on the application by Adobe Walls Gin LP for air quality permit number 151562 to authorize the construction of a cotton gin. The parties have been notified that the commissioners will not take oral argument but may ask questions. Several people have signed in to address the commission. Their presence will be noted for the record.
Commissioner Lindley, on this one, Ms. Copeland had submitted a request for a hearing, and although she met the technical requirements for perfecting a request, I don't see that she is affected in a manner different from the general public. There are really minimal emissions coming from this particular facility, and her residence is roughly 2 miles away. So I just don't see how she can be pulled into that group that has a personal justiciable interest different from the general public.
I agree. And I guess with that, I can make a motion, unless there's other points you wanted to, I didn't want to cut you short.
I think that disposes of the issue. I'll hear a motion.
Okay. I move that we deny the hearing request filed by Ellen S. Copeland, issue draft air quality permit number 151562 to Adobe Walls Gin LP as recommended by the Executive Director, and adopt the Executive Director's response to comments.
The motion has been made. I second it. All those in favor say aye. Aye. The motion carries.
That brings us to the enforcement docket, which is items 7 through 25. The executive director's staff is here to present the matters. And on items 10 and 12, we have individuals signed in who indicated that they don't wish to speak unless the commission has questions. Their presence will be noted for the record.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Janice Hernandez, and I am the Agenda Coordinator for the Litigation Division. With me today are Charlene Backens, also of the Litigation Division, and Brian Sinclair and Melissa Cordell of the Enforcement Division, representing the Executive Director. Pending before you are items 7 through 25. The total assessed administrative penalties are $260,718, with $60,789 deferred, $56,746 applied towards supplemental environmental projects, and $143,228 to the general revenue. The Executive Director respectfully requests approval of these items, and we're available to answer any questions you may have.
Thank you. Any questions for staff?
No, sir.
Mr. McWhirter?
My office reviewed these items, and we support approval of the proposed orders.
I've reviewed them as well, and it seems appropriate to go ahead and approve these orders.
I agree. I move that we adopt items 7 through 25 as recommended today by the Executive Director.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries.
Item number 26 is the consideration of the monthly enforcement report. The Executive Director's staff is here to present this item.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me is Brian Sinclair of the Enforcement Division, and Charmaine Backens and Janice Hernandez of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2019 through December. There were 401 effective administrative orders issued, and of those, 50 contain supplemental environmental projects. These orders assessed a total of $3,370,000 in penalties, with a payable amount of $2,021,423. $736,740 are to be paid towards supplemental environmental projects. 4,775 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 483 enforcement action referrals have been received. There are 1,554 pending administrative orders, with 141 cases that are on the backlog. 216 cases are pending at the Attorney General's office for representation in district court, and 4 judgments have been issued. 2,159 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2017, 18, and 19. We are available to answer any questions you may have.
Thank you. Commissioner Lindley, any questions?
No, not at this time.
Mr. McWhirter?
I reviewed the report. I appreciate the information. I don't have any questions.
Thank you for the report. Appreciate it.
Items 27 through 30 are for closed session, and the commission will not meet in closed session today.
And with that, the time is 10:04, and we are adjourned.